Announcements. Just a heads up, we have a new member that took place of Christy Wilson over at the Rancho Santa Fe Foundation, Chris Sitchell. So he'll be attending as he has a time. Certainly want to give you a heads up on our May 5th meeting. This is going to be a continuation of our Planning for Real Estate Family series with Robert Valera of Voight Real Estate, moderating a panel of Michelle Vivas of Douglas Wilson Companies and Tim Meisner of Meisner's Commercial Real Estate Services. Other upcoming events that we have in June, we've got a good friend of mine, Wendy Goff, ACTEC Fellow of Stoll Reeves in Seattle. She's going to present on one of her areas of passion of the challenges of drafting for beneficiaries with mental health and addiction issues. July 8th, we're just coordinating, having a presentation from an attorney in Hawaii, an attorney in Oregon covering Hawaii, Washington, and Oregon estate tax laws. August, we're still filling out. That'd be August 2nd. No, August 2nd, that's going to be Jeremy Crickard and Phil Sullivan of Sullivan McGibbons and Associates, talking about tax planning for a taxable estate. Want to bring up David Jacobs to just give a few comments on the website. There he is.
Hey, good morning, everyone. David Jacobs with Acumen Insurance Solutions. Good to see everybody. For those of you who are watching us remotely, there's like 35 people here. Everybody's happy. Everybody's full. They're eating food. You should be here. We should try to get more people to come in person. Speaking of that, if you have colleagues that are involved in the estate planning industry and you think that they would be interested in being a part of the council, please invite them to attend a meeting. Certainly they can attend the first meeting complimentary as your guests. So please let us know. We'd really like to have more professionals attend and increase the number of people that are part of the council. Thanks again also for everybody's efforts in registering online when they can. The web address is NCEPC-SD.org. So if you can register for these meetings online, whether or not you do it over Zoom or in person, it would be great if you could do it on the website. And I know some people are having some issues getting onto the website. If you do, just be patient. Be sure to just email me or Bill the exact information that you'd like about yourself on the website, and we'll make sure to have that there for you so all of your information appears correctly and you'll be able to log on really smoothly and RSVP for meetings. Thanks everybody for being here. Anything I missed? Kristen and Lisa, thanks again.
Thank you.
Certainly not presenting today, but our usual hot topic ladies, Katie Swafford of Withersbergman, Roberta Robinson of Robertson and Wilson, and Kristen Shepard, who's just recently stepped down, but thanks to them for keeping us informed on all of the different law changes and both statewide as well as federal. Certainly want to introduce Pete Tentler, who I call expert networker, but a great reverse mortgage expert and more expert than you can really believe. As I hear story after story, it turns into, wow, I didn't know you could do that. But he's going to talk about our trifectas.
Thank you, Bill. You're too kind. I want to thank everyone who has not only been participating in the trifecta, but thank you for the positive feedback that I'm getting from people saying, this is a lot of fun. I really enjoyed getting to know people on a personal level. And I've made some really good connections and discovered things about their industry, or how they're going to be complementing and helping my clients as well. So again, thank you very much for all that. If you haven't done so already, this is the trifecta jar. So drop your card on the way out, and I will try my best to pair you up with somebody that I think will be complementary to your industry and not so much competitor. So thank you very much. My name is Pete Tentler. I'm a certified reverse mortgage professional. And maybe we can do something on Zoom as well. Maybe invite the people from Zoom. So I'll have them put the my email address in the chat room. Okay, thank you.
Pete, thanks so very much. You know, it's all great to have great speakers, Kristen and Lisa. You know, our motto is great speakers on great topics, very good, great planners together. But it's even more fun to hang out with all of you, get to know each other, develop the deeper relationships that allow us to kind of match you up with the right person in solving our clients' needs. So the trifectas is a great way to do that. Without any further ado, I want to certainly introduce, of course, you saw David Jacobs, who's on the board, Phil Sullivan, McGibbons and Associates, Pete Tentler, who's on the board, and Barry Levine of Northern Trust is here somewhere. There he is. Can't see that far. But without any further ado, I want to introduce Lisa and Kristen Caverly. They're with Henderson, Caverly, Pum, and Trytten. And I know their first slide has a little bit of an introduction to them, but I'll let you kind of expand upon that in order to get moving.
Yes, good morning, everybody. Thank you for those of you that have joined us in person. This is my first in-person speaking event in 2 years, so it's lovely to see everybody and meet those people who I've talked to for the past 2 years online or by phone. So, and thank you also to everybody joining us online as well. Today, Kristen and I are going to talk about something that we've seen more and more in our practice in the last few years, and that is interspousal property issues in the context of probate. So punchline, Kristen and I both do trust and estates litigation and administration. So we are always involved typically after one or both spouses have died in a post-mortem context. And the punchline here too is we have seen more and more that people's advisors, real estate agents, financial advisors, CPAs, you may be a very material witness. And so what we're going to talk about today is some of the law that's come into play. And Kristen is joining to give us some war stories and put some factual scenarios to some of the law that I'm going to talk about. Go next slide.
I know many of you and have done business with many of you. And one of the reasons that we wanted to talk about this topic is because we see people often after you see them. So whether it's real estate or financial, CPA, you guys often have dealt with the family leading up to death. And we want to highlight a couple of issues that we've seen. It seems like we are seeing more and more litigation over the characterization of property, whether it's separate or community. And a couple of cases have come down in recent years that have been pretty surprising to practitioners about how the appellate courts see these issues. And you might not be thinking about them in that way. But because of your positions as trusted advisors, you often will have information that would be very valuable to the family or to the litigation attorneys. And so that's the focus that we want to take today. As Lisa mentioned, we are both litigators. We also do trust administration. So complex funding issues also relate to community and separate property. Doesn't necessarily have to be in the context of a dispute, but in looking at the character of assets is obviously going to be important in dividing assets between the two trusts or three trusts when the first spouse dies. I have been a litigator in San Diego my entire career. I graduated from law school in 1994, which is a long time ago now, and Lisa and I have been practicing together for almost 10 years. Our focus is on trust and estates. We have an office in Pasadena, and we have estate planning and complex trust administrations going on up there with Steve Trytten. And many of you know Nancy Henderson as well. She and I last week partners for 21 years. So been a very good partnership. Thank you guys for coming. It's also exciting to be back in person and speaking to real people. I know many people are also on Zoom, but I'm a little tired of Zoom. So thank you for having us in person.
Yes, I'll just add, like Kristen said, I have been practicing in this field for about 10 years now. In addition to trust administrations and estate administrations, I also do guardianships and conservatorships. In general, I look at a lot of the fiduciary issues. I have been interested in this topic for several years. I did write a paper on this several years ago that was published in the Trust and Estates Quarterly. That is equally enthralling and exciting as we're going to talk about today. So if you have any questions, feel free to contact me after this is over. So an overview of what we're going to talk about today. We've really picked 5 main topics to hone in on. The first will just be spousal fiduciary duties and some of the basics of the law to give you all a context of what we're going to talk about later. The second will be death in the midst of divorce. This is something too, we're seeing more and more COVID delays with people getting to trial and finalizing their divorce. Divorce is just stressful. And so what happens and how does property division change if you die during different areas of the divorce? And we'll give you an overview of how that might be affected. The third topic that we'll talk about is titling of assets. This is an area of the law that we thought was settled, but is very much in flux and is changing. And I think it's particularly an area that you all as advisors are going to see people during their lifetimes and may have influence to minimize some litigation for them. Joint trusts and administration after the death of one of the spouses. This is another issue that's becoming more and more of a hot topic. We're seeing more blended families, more wealth later in life, and perhaps the spouses after the death of one of the spouses aren't always honoring what they might have jointly said in a trust or their fiduciary duties, and what happens after that second spouse dies, or what otherwise is the family going to be left to deal with. And lastly, we'll touch on late in life marriages, estate planning that is or is not done, and what sort of rights might come to a late in life spouse. So we'll start with some basics, and it'll just be a very big overview, but spouses owe each other fiduciary duties really to the same extent that business partners owe one another. Spouses have to provide access to all books and records. They have to provide a full accounting if ever asked. They have to provide a complete, true, accurate information regarding the mutual finances. Those of you who are in the fiduciary context see that these are many of the same fiduciary duties you owe beneficiaries of trusts. And also importantly is that if there's ever a transaction between spouses that advantages one of the spouses, it's presumed that the advantaged spouse took advantage of the disadvantaged spouse. And so we need to be considering that during spouses' mutual lifetimes, that they owe each other the highest regard, the highest fiduciary duties. These are all mandated in the family code, specifically section 721. And we have to consider that anytime the spouses are living together, they owe each other the highest fiduciary regard.
They also might do a transaction that they say has some particular consequence to the characterization of property, and that may not in fact be the outcome. And divorce is sometimes different than death. So you might have a particular outcome in divorce and you would be expecting a particular outcome at death, and it might be different. But as Lisa said, if there's a transaction between the spouses, you're going to have a presumption of undue influence if one of them was disadvantaged. You can overcome that, but with clear and convincing evidence. Another thing that's surprising, I think, to people, and we as practitioners only in the last several years have become more mindful of it, is that interspousal claims of breach of fiduciary duty are not subject to the 1-year date of death statute of limitation. So you or I would be barred from seeking any remedy against that decedent after 1 year, but that's not true for the spouse. And that can even be told if there's been information covered up or hidden. And that's true after, when you're helping with tax returns or trust administration and funding, that you also can be complicit as an advisor in assisting somebody in thwarting that spouse's rights. And so not only might you be a witness, but you might also be a party. So those 3 years plus, perhaps without disclosures, is a really long time. And we often don't think about that in administering a trust. Once that 1 year passes and you're free of creditors, you still need to make sure that your characterizations are accurate and that a surviving spouse wasn't somehow disadvantaged.
Okay, so what happens when one of the spouses does have their rights infringed upon by the other spouse? Well, we have to start with the concept that each spouse is presumed, absent a premarital agreement or some other waiver of rights, that each spouse owns an undivided 1/2 interest in the community estate. And so we provide the damaged spouse rights under the law that says if that spouse's interest is impaired, we will allow the aggrieved spouse to file an action against the offending spouse to get an accounting and to get back their 50% interest in the property, plus their attorney's fees and court costs. And if we find that the offending spouse acted with fraud, oppression, malice, then that can include up to 100% of the undisclosed or damaged asset. And an example of this that we've seen in a recent case is a case called Yeh v. Tai. And here, both spouses were deceased, but I could see a very typical scenario happening, which is they had a joint trust during their lifetime and held a piece of real property in that joint trust. And they decided to do a refinance on a mortgage. Well, for whatever reason, the wife wouldn't qualify for the refinance. So they took the house out of the trust, put it in husband's name, and refinanced the home. And then they left it like that. And that might be all fine if we all had mutual beneficiaries, but husband decided that he wanted to leave the property to his children, who were not her children. And lo and behold, after he passes away, litigation erupts about this interest in the home. And we can look through some of the other things that the court said, but the court said that this act, so they agreed to take it out of the trust because they thought they were refinancing it, not because they thought they were going to allow the husband to now own it and give it to whoever he wanted, created this breach of fiduciary duty action. And like Kristen said, this action was brought long after a year. So the trust administration had been going on. We're all trying to administer the trust. And something like 2.5 years later, the spouse files this action and the court says she does have a legitimate action. Next slide. So what happens if people die in the midst of divorce? The purpose of this chart is to show you it's really complicated. So I'm going to give you some timeframes. This is a global overview. And for you all as advisors, it's for you to remember it's really complicated. So this is an area that, again, might start to change, and we've seen some change in the law. But let's talk about the different timeframes and what the results might be. So we'll look at time frame 1, which is, let's assume you have a married couple, they haven't dissolved, they haven't filed for dissolution or divorce. You're presumed to be married for purposes of the law. The only issue that might come up is if you have a valid or even an invalid premarital agreement in which you might have agreed how to divide up your assets. Even an invalid premarital agreement can be enforced against a spouse as a waiver of certain rights of inheritance. So it's important, if there's agreements between the spouses, to let people know that they should have an attorney look at that for them. In that case, you would be in probate court to decide how property would be divided as between the deceased spouse and the now living spouse. What if you have filed for dissolution, the married couple has filed for dissolution, but nothing has been done in the family court and one of the parties dies? What happens there is that typically the divorce action stops. So you have died married and the divorce action stops. You return back to probate court to divide up any assets. This is important because if you choose not to bifurcate and terminate your marital status, then you're going to end up divorced unless you complete the whole divorce process. So if one or both of the people are elderly or ill, it's an area where you're going to want to tell them to consider what they should be doing and talk with their attorney. The third scenario is that you can bifurcate divorce proceedings. So when I say that, I mean there are two ultimate judgments that get entered in a divorce proceeding. The first is to terminate the status of being married. You can be restored to legally single, and then you can wait and divide up your property later. And the second thing that gets entered is that you're actually divvying up the property. And so what happens if somebody dies after they've been declared legally single, but before they've had judgment on the reserved issues like the property division? There, the divorce action continues. So somebody gets put in place of the husband or wife who's died, and the divorce action goes along and the property gets divided up in the family court. That judgment of being declared legally single will also prevent you from inheriting through the family, through the probate court. So, you know, essentially what we're doing is saying, if you've been started up a divorce proceeding, you've gotten your divorce declared, but you haven't divided up your property, you're going to stay over there in family court. And Kristen has a story to tell us about that.
One of the things that we sometimes end up with on when somebody dies is this crossover. We're in probate with certain assets, we're in family with certain assets. And so, as Lisa mentioned, an estate representative can substitute into the divorce proceeding and continue in that department. Now, just like in probate, if you haven't been through a divorce or if it was cooperative, you might not know that there are often many proceedings in the context of a divorce. So you don't just have a trial and then everything is over. Often in a situation where the spouses have different kinds of assets, you can have a trial about one asset. So what are we going to do with the business? What are we going to do with the house? And you might have many of those little trials that take 2 hours or a day or two. And all along that process, you're going to be both in the family court and in probate. But that doesn't change the characterization of the property. So whichever judge you're in front of is still going to have to figure out what is this property. And as Lisa mentioned, just because it is in a spouse's name is not the end of the story. You might be able to prove that it's in that spouse's name fraudulently, or you might be able to prove that just during the course of normal events, we took it out for refi. 2 days later, one spouse dies, and we always intended to put it back, but just didn't get to that. And if you're thinking about your role in something like that, you might be the reverse mortgage person. You might be the person that's helping them buy the property. You might then have information that would be relevant to that proceeding. So why did they take this out? Well, they may have had a lot of conversations with the mortgage broker about why they were taking it out or why one spouse didn't qualify. And that person is going to be an important witness. So for this case that Lisa mentioned, it was a very long litigation, but the divorce was even longer. So 10 years or so before the husband died, there was a divorce proceeding. And it was a complicated, one of these things where there were a lot of different proceedings, The husband participated sometimes, didn't participate other times. Wife participated sometimes, didn't participate other times. The file was very large. So the first thing that we had to do after this man died is figure out what was going on in the divorce, because it had been proceeding over many years. The surviving spouse, the wife, took the position that there was no judgment of divorce, that they were still married, and therefore she would inherit under intestate succession with the 2 children. The divorce had been going a long time, and I thought, gosh, is that, really true? So there isn't necessarily a piece of paper that's very easy to interpret as to where this process is in the between the filing and the status decision and the property division. So we had to go back through the court files on the family law side and get a family lawyer's help as well to go through all of the orders and see what in fact had the court decided and what had the court reserved. We did find that judgment was entered, causing the actual divorce, the severing of the marital relationship. And so we were in both family court to divide up some of the assets because the family court still had jurisdiction over them. But in probate court, we were able to dispute her right to inherit, and ultimately the sons inherited those assets. But there was a lot of crossover. It was not anymore community and separate property issues because the family court had determined that things were community property, but actually dividing them up and then dealing with claims because the division had been ordered 10 years before. They owned some rental properties, but they'd never changed how they managed the properties. The husband had managed them and taken all of the rents. They hadn't divided them. The part about selling the houses, and somebody in this room helped us sell some of them because that was complicated too. The wife was not particularly happy about some of these outcomes in court, and so she didn't cooperate in the sale process. We ended up getting an Elizer appointed, which is an actual court clerk who gets permission from the judge to sign a deed. So these division things can be very complicated, really is the point. And if you are the CPA, if you are the mortgage broker, if you're the real estate agent on some of these transactions, you should be paying attention and realize that the things that are going on between this couple might in fact end up making you an important witness. This case literally wrapped up in January of this year with the final distributions because she appealed, she filed creditors' claims. There was a lot of litigation over this, and unfortunately, it just resulted in a lot of attorney's fees as well. Absolutely.
Yes.
The question is, if you as a professional end up being a witness in a case, maybe you get deposed, maybe you have to go to court to testify, maybe your records get subpoenaed, how are you compensated? And the answer is you are not. So you will get your $15 witness fee. All of us will think that's very helpful. And you do get mileage if you have to drive to the courthouse or to a deposition. Now, one advantage of the pandemic is that most lawyers have gotten very comfortable with remote depositions. And for professionals, I think we will continue to use that because it is less disruptive. We can take an hour deposition without you needing to come down and spend a lot of your time. But at trial, they're just developing these laws in California. But right now, witnesses are required to be in person at trial unless there's a stipulation of the parties. And many of these cases, you can imagine there might not be stipulations about somebody appearing remotely. So it is just part of the cost of doing business. But if you haven't had it happen to you, that's probably a good sign. It doesn't mean it's not going to. The most common thing would be a deposition subpoena or just a subpoena for records. So I want to get the mortgage application. I want to get the bank records, just that kind of invasion into your business, which is still disruptive, but you are often the only party that didn't have any reason to destroy documents or alter them. So I can ask the other party in the case for their documents, but if I really want to know what happened at the bank or at the mortgage broker or with the real estate agent or the insurance application, I would much rather go to one of you. You're much more likely to have complete files, and I don't have to worry that they've been tainted somehow. So unfortunately, you're not compensated for your professional time. Unfortunately, no. Being an American and a Californian, you can be compelled to testify. And the only way that you can refuse to testify is if it is a Fifth Amendment issue. If for some reason your testimony might cause you to be subject to criminal prosecution. Otherwise, no, you can be compelled to travel up to 150 miles to testify. And the reason that you're required to sit for a deposition is if, let's say, the case is going on in San Francisco and you live in San Diego, then you don't have to go to San Francisco to testify, but I can come to San Diego to take your deposition and then use your deposition in court. So it's part of our civic duty. I've been a witness, I've been deposed. I know it's not convenient for people, and I've certainly imposed on a lot of other professionals in the course of my litigating, but it is a very important part of trying to get to the truth and resolve disputes. And often your testimony will help the dispute resolution because you're not biased. You are going to have the documents. You are going to say, this is what husband said to me was the reason that they were taking the property out of the trust and refining it in his name alone. And often that can cut through the rest of the bowl and the lawyers go, okay, well, that person's a good witness. Most likely that's not going to go my way at trial. So hopefully you will see it as part of your civic duty, not just an imposition, but it certainly is an imposition.
Is it the responsibility of a divorce attorney to prepare deeds to real property transferring to spouses pursuant to marital agreement?
Responsibility? Absolutely not. It's nobody's responsibility to prepare deeds, but often if you're doing a transmutation or interspousal transfer, there are deeds that go along with that if they're real estate, and you may be asked to do them. My office often does deeds in terms of funding trusts. We don't do interspousal transfers because we don't do that kind of family law, but most family lawyers do premarital, postmarital agreements, postmarital transmutation agreements that would come up, but I would never say any lawyer's responsible for doing something or has an obligation to do it as long as you can competently give them somebody who will provide it. So you shouldn't do the agreement and then not do the deeds or not make sure that somebody competent does do the deeds if you don't feel you're competent, because an agreement without the follow through is going to most likely cause litigation as well. So we agreed that we were going to transfer this property, but nobody ever did the deeds. That's certainly wouldn't be a good place to leave your client.
And I'll just follow up on that again with this case, which is, I think that question was also directed at a divorce action. And let's assume that the property gets ordered to be divided. If we look at our own case as an example, these parties by the end of it were not participating. So to expect a party who isn't even showing up when their rights are being impaired by the court to somehow sign a deed is probably not realistic either. But if you or one of your clients are the beneficiary of this divorce action and has been given rights to property which has not been divided, this case certainly showed me as an example that you should tell your clients, or if it's you, you should be going out there and trying to be proactive and not wait for 10 years or after the spouse might die, because this spouse did have a lot of property given to her, and property was ordered to be divided 50-50, which in the interim of that 10-year period was just eaten away. So things like retirement accounts also weren't divided up, even though they were ordered. And by the time the spouse died, those retirement accounts were gone. And this person who, although she had been given this property in the divorce judgment, never received the value of that. And there's nothing really that can be done. And so whether it's somebody's duty or not, you guys as the advisors, telling people to take their rights into their own hands is something that I think your clients will be very happy to hear. So the last little scenario on our timeline is, what happens if there's a death after the dissolution judgment? So let's assume, the whole dissolution judgment has occurred. They're legally divorced, everybody's single, and the property has been ordered to be divided. Well, then whatever property division has occurred or hasn't occurred is going to be controlled by that final family law judgment. And specifically in probate, we assume that any gifts made in wills or trusts that were signed before that divorce happened is revoked. So while the trust may still be effective, we essentially take this divorced person out. And Kristen again has a little story for us.
So it can be broader than just the spouse too. We had a case where the trust was actually revoked by the decedent after the divorce. He did not revoke his will, and he was in the process when he died of being with his estate planner and getting a new trust set up. But in the meantime, he had chosen, for whatever reason, not to revoke the will. The will was a pour over will, as is very often done with a trust. So my side argued they were not the spouse, so they were not statutorily disinherited. They were other relatives that had continued to have a relationship with this decedent before he died, despite the divorce. And the probate court here still considered the will to be invalid. So to be revoked, even though it was not the spouse, it was other more distant relatives, but would not permit the will to focus to recreate the trust for these individuals. And the court had to put itself in the decedent's position and decide what the intention of the decedent was. I disagree with the decision, but that's the way that our cases get decided. One judge gets to decide whether this is community property or separate property. One judge gets to decide whether there's a breach of fiduciary duty, typically in our cases. In some cases, you might be entitled to a jury in breach of fiduciary duty situations, but usually in probate court, like family court, you have a single judge that's making the decision. So that person is trying to look at all of the facts, listen to all of the witnesses, and then make some judgment about people that they didn't know based on their understanding, which is why the witnesses, and particularly the unbiased witnesses like you guys, can be extremely valuable to that fact-finding process. I guess the moral of that story is, if you really do like your cousins, you should redo your will. So, or the spouse's cousins, because I think he really did. I think he probably would be unhappy with this outcome, but I didn't get to decide.
All right, we're going to move on to our next topic, which is the titling of assets. And this is an area of the law that very recently, as late as late last year, has been in flux. And so I'm going to give you some of the basics, some of the law that we presumed, all of us practitioners presumed for many years was applicable. And then we'll talk about how that might be changing now. So in general, we have an evidence code in California that says we presume that the owner on legal title is also the owner of the property. So if you see real property titled in John Smith's name, we're presuming that John Smith is the owner of the property. And in general, we require clear and convincing evidence to rebut that presumption. So Jane can't come along and say, no, really, I own it. She's got to have some clear and convincing evidence to change that title. However, we kind of throw this aside for married couples. And we say, instead, we're presuming that if you acquired this property during marriage, we're going to presume it's community property, regardless of how it's titled. So if John and Jane are married and it's titled in John's name alone, but acquired during marriage, we presume that they each own a 50% interest in that property. That's true for living couples under the family code. We don't have anything specific in the probate code that talks about these provisions, but for many years, and for many years, the case law has suggested practitioners were right. We assumed that after the death of one or both of the spouses, that these same rules applied. So if the two spouses were deceased, but they acquired a property during marriage, we presumed that each deceased spouse had a 50% interest. And there are certain cases that seem to be in accord with that, including some Supreme Court cases. And even as recent as 2020 in the Supreme Court, our California Supreme Court applied this presumption to third parties. So these people were married, but they owned a property in John's name. And we presumed that a creditor of Jane could attack that property and get her community property interest in it. And that was all sanctioned by the courts. And again, that is something that Kristen and I and every probably trust and estate practitioner for many years have presumed. But there is some very recent law that suggests that after the death of one or both of the spouses, this presumption of community property may not control. And Kristen, I'll let you talk about that.
So this is a very interesting case, and it was surprising to many practitioners, and I think it is going to evolve either to be narrowed or broadened, but most likely not to be static. So one of the places where this property characterization is important is funding trusts. So if it's spousal separate property, then it's going to be funded into the survivor's trust. If it's community property, then it's going to be divided between the spouses because both spouses own part of that. It's also very important to creditors. So as Lisa mentioned, if you're a creditor out there and you're in a death situation, you have to make a creditor's claim, and then you have to see what assets are available to you to collect on. Community property debts are payable with both sides of the community property, separate debts, separate property. So creditors as well can get involved in these characterizations, and bankruptcy creditors are no different. So you can have this debate going on in the context of two spouses living in a divorce. You can have it in the context of one spouse being dead and trying to divide that up, or you can have it in the context with a truly adverse third party that neither spouse, none of the family, nobody wants to get these assets. And you wouldn't think that the context of this dispute would change the character of the property. And that's what Lisa mentioned. So we figured the same thing that happens in divorce, happens in death, happens with creditors. Now we have a case that says there's a little different situation if it's a death situation. And whereas in a divorce, you would presume that one spouse took advantage of the other and that this was indeed community property. With real estate, at least, if there's a title at death, then we're going to presume that that title is correct. Now, that means if normally a piece of property doesn't say husband as separate property, it just says husband. And so the evidence code property title presumption that Lisa mentioned would say, well, of course, we're going to presume that it's husband's as against the whole world. We need to know who owns this property. But in a divorce, we would never presume first that that was husband's property. We would presume that if it was acquired during marriage, it's community property. And then the burden is on the one spouse versus the other to show it's different. Well, in death, these burdens matter just as much as they do in divorce, because the bar to overcome the presumption is clear and convincing. And you may have heard the criminal beyond a reasonable doubt. You may have heard preponderance of the evidence, which is somebody's got to win and somebody's got to lose. So 50.1% somebody wins. Clear and convincing is somewhere in between those two standards, but it is an intentionally high evidentiary burden. And depending on which spouse dies and the fact scenario, you may have a really hard time proving that this property was not the way that it was titled. So these presumptions really matter. They're not conclusive presumptions, but the imposition of the presumptions really matter. Now, in this case where this big dramatic law came down, the court still found, oh, the spouse showed clear and convincing evidence, so no harm, no foul. But when cases put in some language in a sentence, people like us get really excited about it, good or bad, because then I take that case and I apply it to completely different facts. And one of the cases that we have also was in the midst of this process of litigation before the case, and then also after the case. So when a case comes down in California, which is a published Court of Appeals or Supreme Court decision, it impacts cases that are in the midst of the process, regardless of where in the process they are. So it can change the law that's applying to your case right now. And this was a real estate case, and it may be that the presumption is going to be limited to real estate. It's certainly limited to assets by the case's definition that have title documents, but a lot of documents could be title documents. So maybe the bank statement is a title document. Maybe the share certificate is a title document. Not necessarily something that we would call a title like the pink slip to the vehicle or the real estate deed that got recorded. So that's also in flux, is how broad this is going to be applied. I'll tell you about my case, which is still ongoing. Cheryl's involved with it, and she laughed at me because the last time she touched it was 2 years ago, and it's still going on. And her part is not involved in litigation, but the character of the property, it's some stock in a privately held corporation. It was held in the name of the trust. So it was funded into the spouse's family trust and titled with the two of them as trustees. The wife died first. Nothing was ever done to fund the trust, the two subtrusts. And so when the husband ultimately died, the stock certificate read exactly the same as it had read for 30 years. The two spouses as trustee. So one side of the family said, well, that was husband's separate property, and it related to a business that existed before marriage, and there's a premarital agreement. And my side said, no, it's community property. The corporation was formed during marriage. Therefore, Family Code 760 presumption applies. It's presumptively community property. Premarital agreement didn't directly say, but it gave some people arguments. The titling was complicated because the stock was originally taken in husband's name before it was transferred to the trust. So usually if you're in litigation over something and you end up at trial, it's because both sides have some reasonable argument to make and argue from the facts. So we ended up having a 4-day trial over whether this was community or separate property. Both spouses are deceased. So other than the documents, and literally this company was formed, the original company was formed in the 50s, and then you had some various changes to it and business transactions that were involved. We did depose lawyers and CPAs and got all of these people's records. We had an attorney who was disabled and unable to testify just as a result of age. It was a complicated case to forensically put back together. All of that trial occurred in 2020 before this wall case came down. And so the court determined that it was community property. And we thought, wonderful, now we can get around to dividing up the assets that are still sitting in the administrative trust. The other side appealed, because if you go to trial, most likely you're going to also have an appeal. Otherwise, people settle if they want to settle. If they really want the court to decide, many trials that I've had then end up in appeal. So they appealed, and during the course of the appeal, this case came down. And we said, okay, well, that is potentially really, altering. And the other side as well said, well, that we win, that's going to be clearly we win. So they reach out to our appellate court and say, there's this new case, we should get to supplement our briefing. Our appellate court says, yes, we should get some briefing on how this is going to apply to this case. Now, appellate courts are not bound by what an appellate court somewhere else in California does. They're equal courts. So you can have appellate decisions that are directly contradictory to each other. And that's often how the Supreme Court ends up getting involved in the case. So we didn't know if our Court of Appeals would follow it. Our facts were completely different and not sympathetic in the way that this other case's facts were sympathetic to the particular outcome. So both sides briefed it, and we just had this argument in January of this year, and I'm glad to say we won on appeal, not because our appellate court decided to take on that case head to head. Our case is not published, so it can't be cited as authority. But the court did make a distinction in real estate versus a stock certificate. And the stock, as I mentioned, was titled in the name of the two trustees. So what did that title imply? Now, the other side argued, well, before it was in the trust, it was in husband's name. And putting assets in a trust doesn't change their character from separate to community or vice versa. So they were asking the court to look back many decades and say, well, that was the original character and it held. But our argument, I think, is more persuasive, and the one that will end up impacting a lot of people who are doing trust administration is you don't have property that's titled in the spouse or the husband's name. You have jointly titled assets because they're titled in the name of the trustee. So this might not be as dramatic a case in terms of changing the outcomes for property that's titled husband and wife as co-trustees or even a professional trustee. And I hope so. I think from our perspective as planners and the jurisprudence in California is that community property is really what defines California spousal property rights. And to say that in death, there is a different result than in divorce, I think is something that is not consistent with our public policy and probably not the way that ultimately the law will go. But sometimes these can take 5 or 10 years. And if you happen to be in the district where this case is law, then lower courts are required to follow it, and how broadly they interpret it is likely going to play out over the next few years. But it does make the way that assets are titled very important in your planning, and to make sure that assets are funded to the trust and that the trust is clear. One of the things that we had also going for us was a schedule that the trust attorney had prepared that had community assets and separate assets. And this asset was in the community set. So both spouses had said during their lifetimes, they thought it was community. So all of those factors matter, but there were many people who ended up as witnesses and providing documents as well during the course of that litigation. And we're still not done, because we still now have to get the assets divided. We're in fact waiting for the official notice that we're back down to the trial court from the Court of Appeals. So these are real things that impact real people. And in this case, it's millions of dollars. So it also really matters.
And before we move on, I'm going to talk about one other case just to give further enlightenment onto this. But it's another case that's currently ongoing. But these two spouses, although they did not have any sort of premarital agreement or any written agreement during their marriage, decided to just hold property separately and create their own estate plans. And so they had nothing together. They don't have a single bank account together. Every bank account is in their own separate names. Their cars are titled separately. They have separate homes titled separately, every single asset. And they made entirely different estate plans. Obviously, these were second marriages, one for their respective sets of children. And while they might have arguably had some sort of unwritten understanding between them during their lifetimes, one of the spouses has died, and that has gone out the window. So the other spouse has now made all of these community property claims. And like Kristen said, I suppose we're going on year 2 of litigation with this, and you've really just dragged in the entire family. And unfortunately, nobody's really enjoying any of the assets, which anybody probably intended. And I look at this as a situation where this is a place that advisors can maybe, I don't know if anybody could have changed how this was going, but during their lifetimes, there could have been better planning between them to make it clear what their intentions were and perhaps prevent this situation.
And what you'll find is that in this case, the surviving spouse thinks that everything that was in the husband's name is community property, and everything that is in her name is separate property. So it might be okay if we threw everything back in the pool and divided it up, but dividing one family's assets and not dividing the other is obviously created a complicating matter and set for trial in September. Yes, Mike. I think it would have been helpful in showing that it was community property. The laws, I don't want to criticize the estate planning attorney too much, because the laws about what you need to do to show transmutation have also developed over the last 20 years. And consistent with the presumption of community property, it is hard to transmute something. So you really, really need to indicate your intention to change the character of the property, which is why I hesitate. If that would be enough, we did in fact have a declaration that the estate planning lawyer did that both spouses signed that declared it to be community property. They were aware of this issue. One of the spouses had been through a nasty divorce. They had a premarital agreement, but they left room for lawyers to argue. So if you want it to be community property, I would say not just put it in the chain of title. I would say get with your family lawyer, do a transmutation agreement, so that it is very clear and you use words like transfer or transmutation, because just funding a trust with an asset does not change its character. And that makes sense. We just are holding things as a vehicle in the trust for typically convenience in post-mortem. We don't want to transfer our assets right now. But if you do want to transfer the assets, or you just want to be clear because this is kind of a mucky asset and you've got this premarital agreement that says some assets are this way, get with your family lawyer and do a proper transmutation agreement. And you can even say in there that we're holding title in this fashion as a convenience or to refi or whatever the situation is. Yes, another question. So the question is, what kinds of evidence can be brought in these disputes? And the answer is extremely broad if the documents can be authenticated. So we use the term document literally to refer to anything, including a video, a text, an email, any kind of electronic data we, under the Code of Civil Procedure, consider to be a document. So we have verbal testimony, spoken testimony, and we have documents. So anything and everything, the definition is intended to allow for new technology to still be covered. So any kind of image, any kind of blockchain, it'll be admissible subject to the judge's determination that it's reliable. Always, and you can imagine there's many times with electronic data where people have that as their unfiltered communication. It's always, text messages in divorce always, in just like the same in criminal. So yeah, when I texted you, that I wanted to see you dead, that's gonna still be there. And when you delete it off of your phone, it's not deleted. So you can use some of these fancy, encryption things and surf the net secretly, but as much as people can find, it's still potentially available. And that's why a transmutation agreement is the best intent. Everybody, both sides had lawyers. We thought about it. We did it very intentionally. So it has good evidentiary weight. The text message, that says, I only let you keep that house because you were refinancing it, it's going to probably be admissible, but is it conclusive? Is it persuasive? Depends on the circumstances.
All right, we're going to move on to our next section, which is, we've already touched upon it, and I think we're closing in on time, so I'm going to speed this up a little bit, but joint trusts after the death of one of the spouses, funding subtrusts, and what might your role be? I've gone through the slide to give you just what we're talking about here, but we're really talking about those long-term marriages, all community property or mostly community property. And they have probably oftentimes many years ago signed a trust that they think is for the purpose of avoiding probate. That's kind of the phrase we hear all the time, but has real implications. And so the trust should be divided into two or more subtrusts at the death of the first spouse. And you have one trust, which we typically call the marital trust or trust B. That's the deceased spouse's property. Their half of the community, any separate property that they may have. That is typically irrevocable, unamendable. Maybe the surviving spouse has rights to income or can invade the principal if they need, but the intent is that that is sort of locked in after the death of the first spouse. And then you have the survivor's trust or the trust A, and that's the living spouse's half of the property, their half of the community, any of their own separate property. And generally they get to do with it whatever they want to do with it. They can take it all out. They can give it to whoever they want. It's their own stuff to do with. And you all may be involved in helping them set up the accounts for these subtrusts. You might be managing some of these accounts for the surviving spouse or for the marital trust or the trustee. I think what we'll talk about, but what we typically are seeing is the surviving spouse remarries and they want to start to move some of their wealth into joint wealth with the new spouse. And so again, Kristen here has a couple of stories.
Well, I'm going to give a shout out to Morgan Stanley, but it could be any financial advisor or bank. So one of the things that many banks do or are required to do as you're opening trust is to get a copy of the trust or a certificate of trust so that you know your client. Well, in this particular case, many years ago, Morgan Stanley had gotten a copy of that trust. And when the surviving trustee died, the lawyer for the family, the lawyer for the surviving trustee husband, was then representing that side of the family to administer the trust and sent part of the trust. The lawyer actually did this along with the client, sent part of the trust to the other family because the page break happened to be in a really nice place, and said, this is your gifts. Here's your $15,000 each. And that's all you get. And there are many attorneys who take the position that you get the part of the trust that you're entitled to, and you don't need to see all the other stuff, particularly, the housekeeper who gets a specific gift or the neighbor who gets a specific gift. Maybe they don't need to see the whole thing, and that would typically be justified. But because of the page break, what this family who got the $15,000 checks didn't see is that after the second spouse died, they took everything. But when the first spouse died, they got $15,000. So they had been supposed to get their $15,000 at the first spouse's death. But when the second spouse died, which is now where we were in time, they were supposed to get all of their relatives' assets. Now, the reason that Morgan Stanley saved the day is because there were two co-trustees at the second death, one from each side of the family. And my side of the family didn't know this. They didn't have the trust. All they knew is we got $15,000. Thank you. That was very nice of our relative. But the lawyer prepared a certificate of trust saying that this person in the other family was the sole trustee and sent it to Morgan Stanley. And Morgan Stanley, God bless them, they actually looked at the trust. They could have accepted the certificate. Legally, they could have accepted it. But they decided to look at the trust, and it didn't match who the trustees were supposed to be. And Morgan Stanley said it doesn't match. They're supposed to be two. So then the lawyer came back to my side of the family, to the person who was designated, and said, here, sign this resignation. You don't need to be involved. You got really a lawyer who is licensed to practice still in California. Does not live in San Diego. And my client, thankfully, was himself a financial person, a CPA, and decided, I'd really like to find out what this is about. I'd like to see the trust. And that started to unravel things. And as a result, the families will divide about $5 million, which is what should have happened to begin with. But the point of the story for here is that it really does matter if you're the CPA and you get a copy of the trust. It really does matter if you're the bank or the financial advisor and you have a copy of that trust. Your files really do matter because you're the ones who aren't going to change the pages in the trust. You're the ones that if the family has questions that they can go to your files. And it was such that, even files in the garage had been destroyed. And this was really the last place where the real trust and the whole trust was. So to not discount your part in the role that your files play between the spouses. Yes, George. Sure. So the question is, how long does somebody have to contest the trust? And if you follow the notice requirements in California, you have 120 days from the time that you receive the notice, or 60 days from the time that you get the copies of the trust if you ask for them. So it's a pretty short time. But what we're mostly talking about are not trust contests. So the terms of this trust were never disputed, and nobody would have ever filed a contest. The funding of the trust is always open, because what this trustee was trying to do was steal the beneficiary's money. So that is a 3-year statute of limitations from the time that you discover the theft. So a trustee owes the utmost fiduciary duties to their beneficiaries, and you cannot fail to report your funding choices, your marshaling of assets, your expenditure of trust funds, and expect to have the statute of limitations starting to run.
So if there was never any accounting, that is an open, potentially an open case. Challenged by the other beneficiary services.
Yes, so until there is an accounting, and it doesn't necessarily have to be a formal court accounting, but until there is disclosure, you do not start the statute of limitations. And trust funding is often a very complicated task, and CPAs are very often involved with that. Professional fiduciaries and attorneys are. And it is a good practice to explain to beneficiaries what assets you started with and why you funded them the way that you did. One, to start the statute, so that if you don't complain, I do have some finality, but also because you may not know everything that everyone else knows. And particularly for second spouses or third or fourth spouses, or a professional fiduciary who's trying, when the two spouses are gone, to now make these funding decisions. Lots of spouses don't fund subtrusts. They don't do the administration during the second spouse's remaining lifetime. And so it is often years later that you're trying to fund and make things roughly equal as if they had been done appropriately at the time.
And I will give one example of that, which is a case in which long-term marriage, all community property, very long-term, 50 years plus. They had 3 children, wife dies, and husband decided not to fund the subtrust, to just take all of the property from this trust. So he just removed it all, remarried, which a couple of his children weren't fans of the new spouse, and gave 100% of that property to his new spouse. That all happened in or around 2008, and he died, 12 years later or so. And that was the first time that those children ever saw the original trust that their mom had, or knew anything about what that family owned prior to all of this occurring. I have to give a shout out here to the CPAs because that husband had destroyed all copies, anything whatsoever to do with the original trust. The only way we ever figured this out was that we subpoenaed the CPAs and the income tax preparers for this married couple, and they had their files back from 2008 that included a copy of the trust, and that they had spoken with him about potentially funding these subtrusts and what should be done. So we even had schedules of what they owned when she died. But for these CPAs who kept amazing files, these children probably in all likelihood would have just received nothing, because they wouldn't have been able to prove any of these things. But that gives you, I mean, that was 12 years plus, and we were able to reverse it. It took everybody doing a lot of forensic accounting, and wasted probably a lot of time and money on attorney's fees and other fees after that. But that gives you, a way to see that there is no statute of limitations on something that hasn't been disclosed.
And it is not uncommon for us to see the second spouse, because there's usually co-trustees, and then the first spouse dies, the second spouse is the sole trustee then. That means they own everything as far as the world is concerned. And their children, they might not send the notice out, so the kids don't even get the trust. Everybody, it's just dad, of course, it's his assets right now anyway. Why would I even ask? But as time goes on, people just take stuff. They think that this estate plan, it was great, but now that I'm the second to die, I don't need to follow it, or I'm remarried and I have these issues, or it's just too much, it's complicated and I don't want to do it. Or the estate tax exemption is really high now, so I don't need trust B, right? I mean, I don't need to fund that trust anymore. That was only when the exemption was 600,000. So if you don't know about the terms of the trust, how can you protect yourself in the first place? And that's why we have been excited to talk to some professionals like you guys to understand the role that you can play, both in helping people do what the documents say and honor that so that people get the assets that they're entitled to. But when that doesn't happen, that it really is important, even though it's inconvenient for you to be a witness.
And we'll wrap up really quickly here with our last issue, which is late in life marriages, and some of the potential difficulties that can come from that. And what we're talking about here is, again, a later marriage. And what we're seeing a lot of is potentially somebody gets married, maybe they don't want to tell their family about it, or you laugh, but we've come into this once or twice. Or maybe they just aren't thinking about their estate plan. They're in love. What does that consequentially mean to their assets? They may not be thinking about those things, but the law does. So if you could go to the next slide, please. If someone remarries and does not change their estate plan or otherwise intentionally deal with this new spouse, the law will give this new spouse a share of the decedent's property. That's all laid out. It's all statutory. So there isn't really room for argument here if this spouse hasn't otherwise been provided for. It becomes very much a math equation. And Kristen has probably a quick story or two to tell.
So the first one is a word of caution, because it takes almost no capacity to get married. And some of us might attest to that. Not the current marriage, of course, the last one. But because it takes very little capacity to get married, it is a fundamental right in California. You can have people who are pretty well along mentally, and they can still get married. And this is a common form of fraud and elder abuse. And I'm involved with a statewide committee that assisted in changing the law so that if you have not been married for 6 months, when your spouse dies and they're considered an elder, that there are presumptions that that marriage was the product of undue influence. But also people do get married late in life, and they may not tell their family. They may not want to be judged. They may not want to share that information with everyone, whatever their reasons are. Or people may know that they're married and they didn't change their estate plans. So it is just important to know that when you get married, when your clients get married, it does have implications to their estate planning. They should revisit their lawyers. But they may revisit their lawyer and still not want to do anything. So an omitted spouse is entitled to an intestate share as if there wasn't a will or a trust. And that's for things that do not pass by beneficiary designation. It's for assets that pass through a will or a trust, but it can disrupt a plan in order to get that spouse their share. It can be a surprising outcome. And it often doesn't relate to community or separate property because many late marriages, they don't have much community property, but it can still cause a disruption in the plan.
So we've tried to talk about this, I think, throughout, but this is going to implicate probably all of you in some way. You may be a witness, your records may be subpoenaed, you may be involved in selling property or obtaining reverse mortgages or any of those things. And I think the key for us to you is that you might be a witness. And you might want to think about what your role is going to be as you issue spot for these various things.
Any other questions that we have or anybody online? Okay. Yes. In a trust, you get to use a NOPA pretty much for anything. You can even use them now for preliminary distributions. We are strong proponents of NOPAs. They are only as good as the disclosures. So you still need to have robust disclosures about why you're doing something. And you can do that for funding. I was mentioning earlier, to disclose your funding decisions, a NOPA is a perfect way to do that. But because these people that you're sending this notice to are beneficiaries, they're entitled to your utmost fiduciary duty. You cannot, hide the ball. You only get the benefit of a NOPA and a notice of proposed action in a trust. If I give you this notice, I tell you the material facts, I wait 45 days and you don't complain, then you're precluded from complaining, and it shortens the statute of limitations. In exchange for the trustee getting that shortened statute, you have to have full disclosure. I have used that strategy, and what we've done in that situation is we've said the same way that I do if I need to go to court to get court approval, because you're in flux. So I will usually go with the listing agreement. You might go with a broker's opinion of value, and then you would say an over under. Like, the notices that we'll sell it to a third party with this broker on these commission terms for somewhere between, this range, or plus or minus 10%, or whatever you feel comfortable with. And you might not, have ended up having the right approach, but at least maybe you've gotten ahead of the game. It does require some, perhaps less risk aversion than some attorneys. I mean, often trustees, in order to do their job, accept some amount of risk. So a trustee doesn't need a NOPA to sell a piece of property. They'd like to, because they like to not be second guessed, but the trustee does have authority to sell. And then it's how comfortable are they? Now, right now, you don't sell stuff at list, do you? I mean, it's people waiting around the corner. So, sorry. But if you are doing the NOPA at list and you sell above it, but then you have the same, could have a problem where during the escrow, they ask for a $5,000 credit, for termite damage, or maybe a $500,000 credit, depending on what you're selling. So your NOPA is not going to be a super flexible tool, but you can always get beneficiary consent if they're willing. And that's a good one too, to protect you. Anyone else? Great. Thank you very much for having us. It's really nice to see people.
Kristen, Lisa, thank you so very much. Always fascinating. This actually somewhat coincides with what the estate planners could learn from the estate litigators and administrators, how to do it right in the real world. But thanks so much. Certainly pointing to our May meeting, looking forward to that one. Robert Valera is one of our leaders in that world. Glenn Arnold, Doug Wilson, who was here earlier, kind of the team that helped plan that. Certainly those that have this presentation continues our series on planning for real estate families. So if you have real estate families as clients, it's a perfect meeting for them to come to, because a lot of insights will be coming from these real estate experts. Thanks so much for coming. We'll see you in May.